When you lose a loved one, the emotional shock is almost immediately interrupted by the mail. Bank statements, medical invoices, and final expenses start slamming onto the kitchen table before you even have time to process the grief. Looking at that pile of paper, a terrifying question grips almost every family. Are we personally responsible for paying all of this? The panic sets in that these debts are about to wipe out your own savings. The legal system provides a specific process to handle these bills, one that legally separates a person's final debts from the personal bank accounts of their survivors. Welcome to Know Your Rights USA. I'm Marcus. The very moment a person passes away, everything they owned and everything they owed instantly transfers to a brand new, legally separate entity. We call this entity the estate. Because a deceased person can no longer sign checks or sell property, the government created the probate court. This is a specialized state-level civil court designed exclusively to manage that new estate entity and settle its affairs. Your only job is to help the court sort the estate into two distinct categories: assets, meaning what they owned, and debts, meaning what they owed. By keeping these two categories strictly separated from your personal bank accounts, you can navigate the entire legal system without risking a single dime of your own money. Let's clear up the biggest mistake families make right away. Do not pay the deceased's personal debts with your own money. Outstanding debt is strictly a civil matter, meaning it is simply a dispute over money between private parties. There is no criminal penalty, and absolutely no one is going to jail over a deceased relative's unpaid credit card bill. Unless you specifically co-signed a loan or share a joint account, you are not on the hook. Only the estate is responsible for paying those creditors. Then there is the fear of the government seizing everything through the death tax. This chart illustrates the current federal estate tax rules. The federal exemption is now $15 million per individual. That tiny sliver at the bottom represents a typical middle-class estate. The federal estate tax simply does not apply to most families. Since jail is off the table and the IRS is likely owed nothing, you can safely begin the actual administrative work without the panic. The probate process follows a 10-step timeline. First, procure death certificates and locate the will. Next, secure physical property and catalog all accounts and bills. Step 5, check if a small estate affidavit can bypass formal probate. Finally, open probate and notify creditors. This first phase establishes boundaries. You are freezing the assets in place so the court can accurately weigh what is owned against what is owed. Moving to Step 8, paying the bills. The executor uses estate funds to pay valid claims, but state law dictates the order. Taxes and secured debts sit at the top of the priority list, while unsecured debts like credit cards fall to the bottom. If the estate runs out of money before reaching the bottom of that list, it is declared insolvent. The remaining debts are legally wiped out. Again, the family does not make up the difference. Step 9 brings the final distribution. The court authorizes the transfer of the remaining assets to the rightful heirs, as dictated by the will. Finally, Step 10. The executor submits a detailed accounting record to the probate judge to officially close the estate. The scales are now balanced. The estate entity is dissolved, the creditors have been dealt with, and the family emerges legally and financially secure. There is one final legal detail that can save you incredible amounts of time. Not all assets actually have to go through the probate process. Assets with designated beneficiaries, like life insurance, 401ks, or transfer on death accounts, automatically transfer to the named person. They execute instantly, bypassing the probate court entirely. Taking 10 minutes right now to log in and update your beneficiary forms can save your family months of court time and thousands in legal fees after you are gone. Marcus's message is clear. The law provides a predictable civil process to resolve an estate while shielding your personal wealth. Because civil court procedures vary heavily from state to state, always consult a local, specialized probate attorney to navigate your specific situation. Make sure to subscribe to Know Your Rights USA for more legal breakdowns. We covered what happens when there is a will, but what happens if your loved one dies without one? Find out next time.